Good afternoon and good morning to those of you in the western part of the country. My name is Antonia Fasanelli. I am the executive director of a program in Maryland called the Homeless Persons Representation Project, and I am your moderator today in my capacity as co-chair of the Economic Justice Committee of the Section of Civil Rights and Social Justice of the American Bar Association. Welcome to the section's latest webinar. This webinar is co-sponsored by the American Bar Association's Commission on Homelessness and Poverty, the Center for Public Interest Law, the Standing Committee on Pro Bono and Public Service, the Center for Pro Bono, the Government and Public Sector Lawyers Division, the Commission on Disability Rights, and the Commission on Racial and Ethnic Diversity in the Profession. During the 2018 to 19 bar year, our goal is to rapidly respond to government action that may impact civil rights and civil liberties by offering free webinars, commentary, podcasts, social media posts, and other information from subject matter experts. We encourage you to check out the section's website, which is www.americanbar.org/CRSJ. There's also a Facebook page for the section on civil rights and social justice. And on Twitter, we are at ABA_CRSJ. Latest news and information and replays of our programs are available through all of those sources. If you like our work, we invite you to become a member of the section and collaborate with us on projects you want to develop and offer to our members and the general public. And at the end of this program, we'll talk more about how you can do that. During today's program, if you are so inclined, you may ask questions of our panelists by finding the questions box on the right-hand side panel and typing in your questions. There will be time at the end of our panels to address the questions. There are quite a lot of you. We hope to get through all the questions, but we will do our best. There is also a handout for this presentation that is under the handout section on the right-hand side of your screen. We will also be sharing a recording of this program to everyone who has registered so that you can share it widely with your networks. Please feel free to leave us feedback or ask questions to follow up. Most of all, we are thrilled to bring you today's program entitled Your Money's No Good Here, Source of Income Discrimination in Housing. Source of income discrimination has long plagued folks with lawful sources of income, but particularly low-income tenants seeking housing. Many that are forced to pay rent with government vouchers, veterans benefits, Social Security payments, and the like are often denied housing by landlords. Sometimes these denials are a pretext for discrimination based on other protected classes such as race, disability, national origin, or more. Even when it is not a pretext for discrimination, the impact on low-income tenants, particularly low-income tenants of color, is clear. It contributes to concentrations of poverty, homelessness, and the list goes on. Recent momentum, including the passage of a statewide source of income discrimination ban in Washington state, as well as the recent introduction of federal bills seeking to do the same nationally, shows that we are at a pivotal point in the fight to stop source of income discrimination. This webinar will discuss advocacy strategies for capitalizing on this momentum to pass source of income anti-discrimination laws at the local, state, and federal levels. Today, we have an extraordinary panel of advocates and experts on this issue. With me here in Baltimore is Jill Williams, a board member of the Homeless Persons Representation Project and an advocate for housing here in the state of Maryland. In Washington, D.C., we have Alison Bel from the Center on Budget and Policy Priorities and Phil Tegeler from the Poverty, Race, and Research Action Council. From Washington State, we have Melinda Woods, a Washington State housing advocate, and Scott Crain from the Northwest Justice Project. And in Dallas, Texas, we have Demetria McCain from the Inclusive Communities Project. We're delighted you all can be with us today. To begin, I want to share the American Bar Association's policy on source of income discrimination. As part of the national movement on prohibiting this insidious practice, the American Bar Association adopted its own policy through its own House of Delegates in August 2017, the language of which appears on the screen in front of you. The policy states very clearly that the American Bar Association urges federal, state, local, tribal, and territorial governments to enact legislation prohibiting discrimination in housing on the basis of lawful source of income. The slide provides a link not only to that policy, but the report attached to that policy, which provides a great deal of background on source of income discrimination and its impact around the country. With that policy, the American Bar Association has been able to make public statements in support of legislation prohibiting source of income discrimination. Most recently, the American Bar Association issued a letter of support of a federal bill that we'll talk more about later, that was introduced by and co-sponsored by Senators Tim Kaine of Virginia and Orrin Hatch of Utah. The American Bar Association letter is available through the link on your slide, and I encourage you to read it and use it as needed in your local efforts. We will now turn to a discussion of really why we are here today. And I want to invite my colleague, Jill, to really set the tone for the discussion today with her story. Jill, why are we here today?
We are here today to discuss source of income discrimination in housing.
And how did you get involved in efforts to stop source of income discrimination housing in Maryland?
Let me tell you my story. My name is Jill Williams. I'm 60 years old, and I served honorably in the Coast Guard from 1975 to 1981. After my service, I married an honorably discharged veteran of the U.S. Army, and we raised one child together. I worked as a commercial truck driver and cared for my family. A few years ago, my husband was diagnosed with cancer. I had to leave work to become his primary caregiver until he died. After his death, I had a stroke. With no income and the stroke, I did not have money to afford housing and became homeless. Because of my service to my country, I was able to receive a HUD-VASH voucher, and I was told that this voucher would enable me to live wherever I wanted. But I found that not to be true. I started looking in Baltimore County, Maryland, and most of the property owners said they would not accept Section 8 even from a veteran. And I only had a short period of time to find housing before my Section 8 HUD-VASH voucher expired. So I had to settle in an area where I did not want to live. And I had searched several housing communities and found that none of them wanted to accept the HUD-VASH voucher.
Jill, thank you. I think that your experience with landlords refusing to accept your voucher has been repeated time and time again in Maryland and across the country. And so these experiences have certainly led to national efforts to try to stop this particular practice. And I want to turn it over now to our national experts to talk about their work to try to stop source of income discrimination.
Right.
Alison and Phil.
Thank you, Antonia. I just want to say thank you, Jill, so much for sharing how important this issue is and for sharing your story. I'm sorry that you had such a difficult time using your voucher, especially after all you've done for us. But thank you for sharing your voice with all the attendees today, and hopefully we can work together to make it easier for others to find a good place to call home. So thank you for taking the time to share with us today. I also wanted to say thank you to Antonia and thank you to Paula at the ABA for organizing this webinar today and for including me. I'm Alison Bel with the Center on Budget and Policy Priorities, which is a nonprofit, nonpartisan research and policy institute located in DC. We pursue federal and state policies designed to reduce poverty and inequality. And we focus heavily on the federal budget and tax issues that impact low-income families, and we work to inform debates and achieve better policy outcomes. And we are moving this weekend, which is why I unfortunately cannot be made available on the screen. But I assure you, if you saw my hair today, you'd be grateful I'm not on the video. But because I'm connecting in a different way, if you have any issues with my audio or slides, please let us know through the questions box located in the GoToWebinar, and we'll try to resolve any technical difficulties that might arise. So Phil Tegeler and I will be presenting this section together, and he can share a little bit more about his organization, we known as PRAC, when he gets to his section. What we plan to cover here is a quick overview of the voucher program, research on source of income protections, and a look at where the laws have been adopted throughout the country, and then a brief chat about what's on the horizon in the federal government or in Congress with proposals to expand these protections on a national level. So we're here today to talk about the Housing Choice Voucher Program specifically. As you know, most rental assistance to low-income families is funded by the federal government. Some states and cities have adopted their own local rental assistance program or local voucher program, but the vast majority of families in this country who receive rental assistance, it's funded by the federal government, which sort of relates or connects this disconnect between the federal nature and the federal funding of the voucher program, yet there's not protections for families using these federally funded vouchers. But we'll get to that in a little bit more detail in a minute. So the voucher program, the funding for vouchers goes to local public housing authorities, which administer the program. So the acronym there that you might hear a lot today is a PHA. The acronym for vouchers is HCV, or Housing Choice Voucher Program. And this program, the voucher program, serves over 5 million people in over 2.2 million households. So that's 2.2 million different families who are using this voucher to rent in the private rental market. But what we know about vouchers is that they sharply reduce homelessness, they lift families out of poverty, and they give families an opportunity in the local rental markets to move to safer neighborhoods. A voucher can help improve children's educational outcomes, health benefits, and long-term prospects for children to thrive. The voucher, the federal funding for the voucher, helps families pay and fill the gap between what the family can afford to pay and what the local rents are. So the entire design of the voucher program is reliant on the private rental market. But as you know, and as we all know, landlords are not required to take that voucher. And we've heard a lot about how challenging it can be for families to find units. And while it is indeed very challenging, and we're going to talk about some of the research today that demonstrates how challenging it is, and there's a lot we should do to make it easier, I do want to note that not only do vouchers help reduce homelessness and support children as they're developing, but the voucher program is actually quite successful at helping families rent units. I know it might not feel that way or feel like the experience, but last year, housing agencies in this country spent 99.9% of all the funds that they were of all available funds to provide rental assistance. So we're going to talk today about strategies to make it easier for families to rent units, but I do want to be clear overall that the voucher program is a pretty successful public-private partnership, and as we talk about what we can do to strengthen it, keep that in mind. But as Phil's going to cover in a lot of detail, many landlords outright reject vouchers, and to help mitigate this, some states and local jurisdictions have adopted source of income laws. And if you don't mind advancing the slide. Thank you. So as we've talked, there's no federal protection currently, but when we talk about these laws, you might hear us talk about them in a couple of different ways. So we're calling them source of income laws, which people shorthand as SOI. And you might hear me refer to these as voucher non-discrimination laws. The term is somewhat interchangeable because most jurisdictions that have source of income laws ensure that voucher holders are specifically covered by that law. But it's important to note that unless vouchers are specifically covered by the language in that source of income law, voucher holders might not be covered. So these, and that's because some of these laws are written to cover, they're written to cover more than just vouchers. They might prohibit discrimination based on alimony or disability benefits. And there's a lot of variation in how the laws are written, which is why it was so helpful that the ABA came out with their resolution to kind of think about the best ways to present this concept. I'm just going to give you a brief history of, back one more, but that's okay. So I'm going to talk more about a paper that we came out with earlier this year, where we look at the history of source of income laws and a bunch of other things. But the first source of income laws were adopted in 1971. And then after that, 5 more jurisdictions enacted them, followed by another 20 jurisdictions between 1980 and the year 2000. But they've surged since then with more than 50 additional jurisdictions adding them. And this number, 50 since 2001, doesn't account for some of the laws that have passed within the past 3 months. So there's a lot of momentum around these laws. And I'm excited to talk to you a little bit later after Phil covers the research about where these laws are and how many families are covered where. So for now, though, I'm going to turn it over to Phil to talk about the research.
Thanks, Allison. I'm Phil Tegeler with the Poverty and Race Research Action Council in DC. We are a civil rights policy organization that works on housing and education policy with a big emphasis on racial and economic integration in schools and housing. And we do, for that reason, we do a lot of work with the Housing Choice Voucher Program, trying to deal with the barriers that prevent families from moving into lower poverty, higher opportunity areas. Issues like source of income discrimination, small area fair market rents, and various aspects of Section 8 program administration, which create barriers for families. We published in 2005 as an appendix to a housing mobility report, an appendix B, we called it, to that report, which listed the all of the extant source of income discrimination laws at that time. We've been keeping that updated a couple times a year ever since then. and it's doubled in size. The appendix keeps getting bigger and bigger. And our last update, which is on our website, and you'll get a link to it with the materials, was from September of last year, or September of 2018. And as Alison mentioned, we already have 6 new ones we have to add next month. So it's a work in progress, which I recommend to you. So I wanted to talk about this big new HUD study. It's called the Pilot Study of Landlord Acceptance of Housing Choice Vouchers. It was written primarily by Mary Cunningham and Martha Galvez at the Urban Institute, and a whole team of researchers there at Urban. Urban Institute is the think tank that has been responsible for a lot of research, but importantly, the housing discrimination studies that HUD does every 10 years to sort of track the extent of racial discrimination in housing. They've also done studies on disability discrimination. So they're kind of the gold standard for measuring discrimination. And in this study, which is the first major national study that HUD has done of housing choice voucher discrimination, they did 14 months of testing. They tested over 341, they looked at 341,000 online ads and made over 16,000 contact attempts, initially through phone calls and then following up through in-person testing. The testing was focused on 5 metro areas, which you'll see in a subsequent slide. And the primary purpose of this study was to test the extent of housing choice voucher discrimination in both throughout the metro area, and also comparing the higher poverty versus the lower poverty areas of the metro. They found extensive discrimination, as you'll see, which was even greater in the higher opportunity, low poverty areas. But there was a bonus finding in this report, which was kind of unexpected. 3 of the metro areas in the study had source of income discrimination. 2 of them had very effective source of income discrimination enforcement regimes, specifically Newark, New Jersey, and Washington, D.C. area. And I should point out here, the study was not set up to test the proposition that source of income discrimination laws led to lower rates of discrimination. So we can't say, or social scientists are not able to say that the source of income discrimination laws in Newark and Washington, D.C. caused the lower rates of discrimination. But as a non-social scientist and lawyer, I think the association is quite obvious. And if you go to the slide with the 2 bars on it, there, right there, thank you. This is averaging the jurisdictions with source of income discrimination laws versus those without. And you see, there's twice the rates of discrimination in the jurisdictions without source of income discrimination laws. So this answers the basic question: does it make a difference to have a source of income discrimination law? Will there be lower rates of discrimination? And the answer is yes. And the rates, as I said, are even lower in those jurisdictions with the really strong enforcement regimes. So you can move on there.
Keep going.
And next, keep going. That's good. Okay, so here you see the rates in Newark, New Jersey, and Washington, D.C. of voucher denial at 30.9% and 14.8% respectively, compared to extremely high rates in the other places. So the question is, going back to that long bar chart, what's different about these places? And I think our observation at PRAC is that there's just very strong enforcement setups in these communities. There's a functioning Human Rights Commission that accepts complaints, investigates complaints, and prosecutes complaints. There's an option of going either through the administrative agency or to court, which is really important. There are attorney's fees that are available for successful plaintiffs or complainants in these cases. And there's, especially in Washington, D.C. area, there's a very strong coordinated enforcement effort and systemic testing that's going on. So if you see where you have all those things together, you'll tend to see rates, very low rates of voucher non-discrimination. Now, of course, there's other things happening in D.C., of course, very high exception payment standards targeted to high opportunity neighborhoods. Source of income discrimination protections are not the only thing going on in Washington, but this is a very telling chart, and you can move on.
One more, Phil?
Okay, yes, thank you. And so I'm going to, could you go back to the research slide? Thank you. Very briefly, I want to characterize previous research on voucher non-discrimination laws. The bottom line in the research is that laws against source of income discrimination lead to higher success rates, which I'll explain in a minute, and higher utilization rates for housing voucher families. But there's very mixed evidence on whether source of income discrimination laws alone help families get into lower poverty communities. So I'll just quickly go over that. The success rate, of course, is the percentage of new vouchers that get leased up. In other words, how successful are families when they get a voucher in finding a unit and leasing it up? That's called the success rate. The best studies that have been done showed a 12% increase in success rates in jurisdictions that had source of income discrimination laws. So it makes it easier for families to lease up once they get a voucher and not have to return it back to the housing authority. Utilization rates is something very important for public housing authorities. That's basically the number of leased units divided by the number of units they have under contract with HUD. Are they able to use all their vouchers in a given year? The HUD study on this issue found a 5 to 12% higher rate of voucher utilization. And again, the studies asking the question, does it help families move to lower poverty neighborhoods, have not shown really strong evidence that source of income discrimination laws alone make that happen. Obviously, you need a source of income discrimination law to make it easier to move into those areas, but you have to have other things as well, like the small area fair market rents and other administrative practices to help families move into those communities. Next slide. And this is simply breaking out from the HUD study the differences in rates of voucher discrimination in region-wide versus low poverty neighborhoods. And as you might expect, the rates of voucher discrimination are higher in low poverty neighborhoods. But what's striking here is how much difference it makes in those communities that have strong source of income discrimination laws, Washington, D.C., and Newark. Even in the low poverty areas, there's much lower rates of discrimination in those communities with strong laws. Next slide. And we're back to Alison, I think.
Okay. Thanks, Phil. So the PRAC appendix B that Phil referenced earlier was relied upon extensively for a new report that we came out with at the center in October. So I'm going to talk for the next couple of minutes about this new report that we issued that focused exclusively on voucher non-discrimination laws. And the link to this report is included at the end of the slides. And spoiler alert, we just updated it today to reflect a couple of new federal proposals but we'll be updating it again in January or so to reflect the 6 new locations that have adopted source of income protections. So for details on the specific types of laws that have been adopted and a good bit of legislative language, the PRAC report's where you want to go. It is, I don't know what to call it, the main resource out there that I've seen that really articulates what's in each law. But what our report does is kind of take it, I don't know if I would say up a couple levels, but more of a summary of what's happening with source of income protections, and it also looks at the research that Phil just discussed. So what we did was we conducted a range of interviews with, voucher policy experts and practitioners at the national, state, and local levels, including advocates and legal aid and program administrators from the Housing Authority. And they shared with us their insights about how to enact voucher laws and how to improve existing voucher non-discrimination laws. So without knowing exactly who's on the call, if you already have source of income protections and you're interested in strengthening them, or if you're here to learn about how to adopt a source of income law, this paper is trying to address both audiences. And then the folks that we talked with were selected to represent cities and states and counties with all different kinds of political environments, forms of government, and types of protections. So that report is a good resource to go to learn a little bit more than we're going to cover today. But the thing I think is the most fun about our new report is this interactive map of where voucher non-discrimination laws are. And this slide in front of you is a static map, meaning the slide does not show how awesome this interactive map really is. So you'll need to go to the link at the bottom to use the map as intended, which allows you to mouse over each location and hover over the text, and it's going to show you how many voucher holders are covered in that area, and you can drill down a little bit more to see kind of where the laws are. We also have in that report that I mentioned 2 appendices that show the localities by the year adopted, as well as the number of voucher holders covered. So if you're working at the state level, thinking about adopting a law, and you want to know how many voucher holders are currently covered in your state, this could be a resource to identify exactly how many families are currently being served. You can go to the next slide. So the first slides that I'm about to talk about are about strengthening existing laws, which are good lessons learned to think about if you're adopting new laws too. Because these are kind of lessons learned from places that have already blazed this path. So what we've heard from places with source of income laws is that while the law can be really helpful to help voucher holders better access units, a lot could be done still to improve the implementation of the law and make it more effective. And as Phil mentioned, enforcement is incredibly important. So there's a wide range of things that could be done to improve the enforcement of the law, making sure that you inform families, participants in the program, and landlords of the requirements. Make sure that the voucher agency knows how to let the enforcement entity know about violations, and that families know how to report those violations as well, and share information with each other about how many violations are being received and if they're being resolved. There should be a mechanism to collect, investigate, and remedy the complaints. That doesn't exist everywhere. And as Phil's mentioned, it's important to do regular testing to ensure compliance. And one of the really great things that came out of the urban study is a detailed guide of how to effectively do this kind of testing, which could be, for your fair housing enforcement, a really helpful additional tool to how to test for landlord acceptance of vouchers. And then Phil talked a little bit about some effective legal, I'm not a lawyer things. So I'm going to defer to him, and Demetria can jump in, but basically ensuring that lawyers who are helping to enforce source of income laws are able to get attorney's fees. So the next slide, and I know we're running a little short on time for this section. One thing that we heard was that there should be a broad advisory group that's providing oversight for the implementation of these laws. So once the law is passed, it doesn't just stop there, that maybe the coalition that helped get your law passed still works together to make sure it's being enforced effectively, and that there should be regular engagement and ongoing communication with landlords, voucher holders, and housing agencies. All right, the next slide. So what we heard from agencies or from localities that wanted to adopt new protections, and from their experiences in places that had just adopted them, is that the language has to be both broad to cover voucher holders and other groups, but also needs to be very specific. You need to make sure that that law actually covers voucher holders. And then I think second to that, we heard that the reputation of the local housing agency matters enormously. And there's not a lot that each of us as individuals can do to improve either the reputation or performance of a local housing agency, but to be very mindful of how that perception in the community is, and think about any strategies that might be able to be implemented to mitigate that. Probably pretty obvious, but it's important to build a broad coalition and to make sure to engage landlord groups. Landlords are very important partner in administering the voucher program, and most landlords want to provide great rental units for clients, and they're just important partners. So it's good to engage them up front. Even if they might not agree with you, you can see where you can come to some level of agreement, and at least know where they're coming from, which will help inform any campaigns that you're taking or moving underway. And then what I heard, and maybe Mindy might be covering a little bit of, is that there's some long-standing myths about the voucher program based on some rules that existed before I ever got into this world, and I've been doing this for 15 years, that of how the voucher program used to function, like you couldn't charge security deposits. And so some landlords have this mistaken idea about what the voucher program is, and it's important to reinforce what the voucher program's policies really are. Like, landlords can use their regular screening criteria, they can charge market rents, they can charge security deposits, and then there's a couple of other, more positive aspects, that PHAs generally pay the rent on time, and voucher holders have a lot of incentives to maintain their unit and pay their portion of the rent. We talk about this in more detail in that report I mentioned. I would encourage you to take a look at it. And then I failed to include a slide on this, and I'm so sorry, because I know people are very interested in this, but there's a number of federal proposals in Congress right now to adopt a federal source of income protection. Senators Crain and Hatch, which Antonia mentioned earlier, they introduced a proposal recently, and Elizabeth Warren, Senator Warren's rental proposal included language to prohibit discrimination against voucher holders, and Representative Velasquez has introduced a similar measure for two different terms, two different congressional sessions, and then back in 2013, Senator Brown from Ohio, who's I'm trying to calculate in my head how many of those names I just mentioned are possible presidential contenders. He also introduced a proposal. So there's a lot of interest at the federal level about adopting a source of income protection. We aren't sure exactly where these proposals will go. If I had that map back up, I'm not telling you to go back there. Utah has source of income protection, so Senator Hatch might not come first to mind as someone who might be a huge advocate for this type of law, but it's my understanding he's very passionate about this issue, and him and Tim Kaine have partnered on this law. So we'll see where it goes, and I'm happy to answer any questions about it. But I think the short answer is there's clearly a lot of interest. There's bipartisan interest, and perhaps this could be a moment for these laws. And then here's a list. After this is over, you'll get copies of the slides, and here's the actual links to some of the reports that we discussed today. So with that, I am turning it back over to you, Antonia, I think.
Alison, thank you so much. And Phil, thank you so much for that federal overview. That's incredibly helpful. And I just want to emphasize for listeners on the phone, the Center's recent report that Alison referenced, the October report, that's the first link in your resources. And the Appendix B, as we call it, the PRAC appendix that summarizes and tries to keep up to date with all the source of income laws around the country. That's the second link in the resources page. We will go ahead and advance our slides now there is contact information for Alison and Phil on that slide. We will go ahead and move on to Washington State now. And we have two really extraordinary advocates from Washington State to talk about the recent success there. Melinda Woods is a housing advocate there. And Mindy, I believe you're on the line.
I am. Good morning.
All right. Yep, go ahead.
So thank you for having me on, and a little bit about my story. I am a single mom, also a Navy veteran of the Persian Gulf War, and back in 2010, I was in an apartment with my son, and it got taken over by black mold. And during that time, my son and I both had health challenges. My son had type 1 diabetes, and I had multiple autoimmune issues as well. And so we got to the point where the mold became so bad that my son was hospitalized for 4 days. And so we had to evacuate our apartment. And that led to homelessness for us for 8 months. And we eventually got into a YWCA shelter and put us a housing choice voucher. And we got into an apartment and got reestablished, really started to just kind of get our life back. Our health was improving. My son was in high school at the time. And so he was really starting to thrive again. And 3.5 years later, all of a sudden, we got the 20-day notice, which is Washington State's law, that our landlord was not going to offer us a new lease. And so I scrambled and could not find a landlord to rent to me with a stellar rental history, but simply because I was on Social Security disability and I paid my rent with a Section 8 voucher. And so that began another 8 months of homelessness. Unfortunately, though, at that time, my son was 18, so we were no longer eligible for the shelter. And so sadly, we had to break up our family. And my son had to go and stay with a friend and his mother. And I had to go and couch surf 4 different houses and just bounced around from couch to couch for 8 months. All the while actively searching for a rental with my voucher. And like I said, I had a stellar rental history. There was no issues whatsoever, a 30-year solid rental history. And but I just could not get a landlord to accept my voucher. And in talking with landlords, I would hear that many had this misperception, or maybe a perception of that was an old perception of the Section 8 voucher program from the 1980s. And I think there's been a lot of improvements since then. But for instance, I would educate landlords that not only are you getting guaranteed income, but you're going to get it on time. And for me to qualify for the program, I had to have a yearly inspection, which landlords weren't doing that. So I was, somebody was at least overseeing that I was, somewhat clean, that I wasn't a hoarder, I wasn't doing illegal activities in my unit, that everything was in working order, which protects both landlord and tenant. And even little things like I wasn't supposed to be behind on my utility bills or even have a missing light bulb. That literally, this was a great program that protected both the tenant and the landlord. And so it was a great win-win. But for some reason, many landlords have this misperception and either had never been in the Section 8 program or had gotten out and had not realized that things had changed. So it was an opportunity to educate landlords, but unfortunately I couldn't get them to enroll back in the program or start in the program in time. And so the Section 8 voucher, when you are in between addresses, it has an expiration date. And so because I could not find a unit in time, I had to file for an extension. And fortunately, my Snohomish County Housing Authority, did offer me one extension, but I was told by my caseworker that because there were so many voucher holders out there with nowhere to go, there was no point in giving me a second extension. So I literally found my apartment 2 days before my voucher expired. And I am just so grateful for that. But I had started testifying on this particular source of income discrimination 4 years prior to my actual experiencing homelessness and discrimination. I had been homeless once before, like I said, with the black mold situation. And when we were in the shelter, I was asked if I wanted to go down to our Capitol and testify on this bill because without it, we would not have the protections and would not have the program that I was going to be entering. And so I had been passionate about this prior to actually experiencing that actual discrimination. And so once it happened to me, I really got involved in trying to educate landlords and just talking with the public in general, but really talking with my lawmakers. And I do a lot of advocacy through the Washington Low Income Housing Alliance, and we have an advocacy organization called Resident Action Project made up of those folks who have experienced housing instability. And so we've spent a lot of time talking with our lawmakers. And so a year ago, when this bill came up again, it had actually been 9 years we had been pushing for this. But when it came up again last year, I met with a particular senator that was a landlord herself and had rented to Section 8 tenants in the past and had been a no vote on this bill. And just had the opportunity to really talk with her about what this impact had meant for me, how it had impacted my son negatively, and how that there were so many people that really needed just this hand up, not necessarily hand out, but that it would really give them an opportunity to get, reestablished and to kind of pull themselves up, whatever the financial crisis was that led them into their situation. But it was just a great platform or a foundation for people to really reestablish themselves again. And so after our meeting, we in Washington State, we have a particular part of our bill that is called a landlord mitigation fund. And so she wasn't aware of that. And so has had the opportunity to really kind of educate her and inform her on what we were looking at. And fortunately, when session started in January, she ended up being a yes vote, and she was the swing vote in our Senate that got this bill across the finish line. So it's a huge victory for our state. And it doesn't cost the state any money. It's already a federal HUD program, so it's really a win-win-win all the way around, and helps to alleviate the enormous pressure on our resources, so that these folks can get into a solid, stable place, and those who are on the, our particular county's an 8-year wait list for a Section 8 voucher. It alleviates that pressure and gets folks with a voucher in hand into a stable place to call home, and you know, helps the economy, helps the community. So it's been a huge victory for us. So I'm really excited to have been part of it.
And Mindy, many congratulations to you, and thank you so much for sharing your story here today. Again, another reminder of why it is so critical to stop this practice of discrimination, and it's really a credit to you and all the other advocates in Washington State that you were able to get the law passed, and it's just fantastic. And so with that, I'm going to turn it over to your colleague in Washington State, Scott Crain, to talk in more detail about the strategy. Scott?
Yeah, thank you, Antonia. Yeah, there we go with the slide. So I'm Scott Crain. I'm an attorney at Northwest Justice Project, which is an LSC-funded organization in Washington State that provides free legal services. I'm also a member of the APA section on civil rights, so I'm really happy to be here to talk about this. If you're familiar with LSC, we can't advocate for the passage or defeat of legislation. We don't generally engage in legislative activities, but we have some exceptions to that where we can provide information to legislators in certain circumstances about the impact of legislation on low-income people, and to our colleagues about how legislation would actually work, because we're on the ground representing tenants every day. And so I'm going to talk a little bit about what the bill, the environment that the bill came into this year, and why it was successful, and talk a little bit about the structure of how the bill protects people with vouchers or other sources of income from subsidies or assistance. But if you're familiar at all with Washington State or Seattle in general, we are in the midst of a huge housing boom, and there's just no housing available for low-income people, or people of really any moderate means. And one of the things we were seeing earlier this year, in the last couple of years, was developers coming in, purchasing multifamily properties, and attempting to flip them. And one of the strategies there was to, the first thing they did was evict all Section 8 tenants, because the strategy was to market these up to a higher demographic. And so we were seeing throughout the state really whole buildings being told that Section 8 wasn't welcome anymore. And one particular instance about 2 years ago, in a sort of first-ring suburb of Seattle, what had happened was a developer came in, kicked out all the Section 8 tenants, and then we started working with the Low Income Housing Alliance and the Tenants Union, and finding out that all of these tenants were African-American families with children. And so, you know, we prepared to bring a fair housing lawsuit on that, which, as you can imagine, is remarkably more difficult than just having a law that says it's illegal to do this. But, you know, we thought we had a decent case. What ended up happening is we were negotiating that litigation, and the city in that suburb outlawed source of income discrimination to sort of stop this from going forward. So we had sort of a small success there, but that really told us that this was a huge problem. The voucher holders just didn't have a lot of protection, and for us to jump in and protect them was a significant expenditure of resources that we just couldn't do on a statewide basis. So that was the year previous, and then as Mindy said, coming into 2018, there was a lot of energy around this. The Low Income Housing Alliance had organized an amazing group of advocates, which included people like Mindy, who had experienced discrimination, landlords who were happy to rent a Section 8, housing authorities who could talk about the impact on low-income housing in their communities and to their legislators, and just a really broad spectrum of folks to say, you know, why it was important to outlaw source of income discrimination. What ended up happening is people like Mindy who were able to talk about that experience, and then landlords who were able to talk about dispelling some of the myths of Section 8 really helped with skeptical legislators. And that's because the two of the biggest myths are that Section 8 people are bad people, and that dealing with housing authorities is a terrible pain, and landlords don't want to do that. And the advocates that spoke to their legislators and to the legislature were really effective at dispelling some of those myths, showing that Section 8 tenants are significantly more vetted than other tenants in terms of their backgrounds and ability to pay the rent, and that a lot of what goes on with housing authorities now is so much more automated than it has been, that a lot of those myths are based in not in reality. So that helped push this over the top this year, and we ended up with a law that, if you look at it, it's in the revised Code of Washington 59 .18.255. You can just Google that and get straight to the law. But it looks a lot like a fair housing law in the sense that it prohibits a landlord from not renting to somebody with their source of based on their source of income, and then it lists about 10 different ways that that's illegal, including refusing to rent or kicking somebody out, distinguishing in the provision of rentals or terms of renting. Advertising is illegal, to say no Section 8, that's illegal. Telling somebody that they don't have an apartment when they actually do because they don't want to rent to Section 8. And then the sort of catch-all is to otherwise make unavailable a dwelling based on someone's source of income, which, again, looks a lot like a fair housing law. For reasons that based on how the legislature works, this landed in our rental housing code, not in our human rights laws. So there is no automatic enforcement agency. Source of income discrimination or renters are not now a, quote, protected class, which was, I think, something that a lot of legislators had questions about and concerns about. And it ended up, a couple of the other compromises that ended up in the law looked at, well, how is this enforceable? And it's really enforceable by a civil action. So somebody has to bring a lawsuit, and they can punish a landlord who won't rent with damages, attorney fees, costs, and probably injunctive relief to require them to rent. And so that was one of the big compromises, is that we don't have an automatic enforcement mechanism for this law, and tenants really have to be knowledgeable and assertive about this and enforcing their rights. I think what we have seen is that management companies, professional property managers, and landlords, this pretty much disappeared after the law became effective, in the sense that it's not advertised as such. The places you tend to see no Section 8 discrimination advertised would be like a duplex somebody's renting, or a non-professional landlord renting out a house they inherited. And, we'll just sit during our lunch hour and go through Craigslist and flag those ads and try to beat some of that back a little bit just on our own free time. But that's not to say that underneath that there's not still discrimination going on that we have to be concerned about. And that the law was intended to address that in some ways, such as we have a very specific provision that says if you require a certain amount of income to meet the rent, like you got to have 3 times the income to meet the rent, you have to count the voucher too. You can't say, well, you only have TANF, and that's $400 a month, and therefore you don't have enough to rent here. You have to count the voucher assistance in that calculation, which we were concerned that would be one way landlords would decide they didn't want to participate in the program. Another way is everybody that leases up for the first time with a voucher has to have a 12-month lease in most circumstances. And so the law basically says you can't refuse to rent because someone uses the voucher, and that we believe there's enough room in the law to say if you've got a policy that says we only offer month to month, well, you've got to make an exception for a voucher holder to allow them to rent. So it's things like that around the edges that concern us now, not so much broad prohibitions of kicking out all the Section 8 tenants or refusing to rent to Section 8 tenants as a broad policy. I think it's in the details of how landlords are working with tenants and working with the programs to make the housing accessible and getting people into that housing. A couple other little details of things that came up during the legislative work was local preemption was a big question. We have local jurisdictions that have broader protections for tenants, and there was a question of whether this should preempt local protection, and it does not preempt local protection. So cities and counties are still free to provide broader protections to new protected classes, to enforce the law themselves or their own laws themselves. And it was very important that this didn't circumvent the ability of jurisdictions to address discrimination that's happening in their own backyard. So that was significant, and it was discussed, and we, that was something that was thought about pretty heavily during the process. I would say work still remains to be done in terms of figuring out where all we need to be looking for discrimination and how we can enforce this. I mean, I think there's things that could have been done differently, but it's a great law. People like Mindy were critical in helping this overcome the hurdles that existed in showing the real face of discrimination, and that this really takes a big step forward in getting a lot more compliance and really stopping a lot of those problems of buildings just trying to empty out their Section 8 tenants when they want to appeal to a different demographic. But like I said, resistance is in the details, and making sure we understand where that happens and that this doesn't continue on in some sort of less obvious forms is what we're looking at now, and just kind of seeing how it goes forward. Mindy also mentioned the mitigation fund. I'm not going to talk a ton about that, but that was sort of a carrot to help bring landlords into the fold on this. But really, I think the law just really puts into our code what fair housing law says, which is you can't discriminate on people because of how they pay their income, because that has so many more impacts on people of different ethnicities, races, disabilities, and family status. And we're just looking to make sure it's enforced now. So having us, and if we have questions, we'll be around to answer them.
Scott, thank you so much for that summary. That was super helpful. I just want to bring up one question that was asked because, Scott, you touched on it in your talking points. One of our listeners has asked about dealing with property owners that require income to be 3 times the rent. You touched on this by saying, of course, that the voucher has to be considered as income in that calculation. Another piece that's critical is that once source of income is passed, landlords can't treat voucher holders differently in terms of income qualifications and other tenants in the property. So I want to emphasize that. And Scott, I want to invite you to make any additional comments on that point about income requirements.
Sure. So, I mean, this is, it's pretty prevalent practice, I guess I would say, is that you got to have 3 times the income to rent here, or something like that. And I mean, the law specifically just says that it's subsection 3 of our statute, and it says that if the landlord requires a threshold of income, you've got to subtract from the monthly rent the amount of the voucher subsidy, and then look at, because you're looking at the tenant's total payment there, and whether they're going to be able to pay what's left over after the voucher means it. So it's not super complicated math, but that's what we were attempting to address. Does that answer your question? No, Phil, looks like you had a question too.
Well, no, I was going to say that I think most courts that have looked at that attempted defense have dismissed it pretty quickly because the tenant, by definition, has more than 3 times the monthly income to pay their portion. So that has not been a successful argument, even in ordinances that don't specify it.
Great. Thank you, Phil. And I also wanted to respond. Someone asked about where the handout is. It's under the handout section on the right side of your screen. The handouts little tab is right under the questions tab, and you should be able to access it there for any listeners who may have missed the introduction and the instructions there. But thanks so much to our Washington State folks, and we are getting more questions, so we can certainly turn back to Washington State. But for the moment, we are going to turn to Dallas, Texas, and Demetria McCain from the Inclusive Communities Project. Demetria, go ahead.
Hi, first of all, let me say thank you for hosting this, Antonia and ABA. This is a super duper important issue, particularly here in Texas and in Dallas where I am. And I also want to commend Mindy and all of you guys as allies. Your story is encouraging to us, and hopefully Texas will get where you are right now. Next slide, please. So very briefly, the Inclusive Communities Project is a not-for-profit fair housing organization located here in Dallas, and we actually work regionally throughout the Dallas region. We have a 3-part mission, which is to create and maintain racially and ethnically inclusive communities throughout our region, and to expand fair and affordable housing options for low-income families, as well as seeking redress for policies and practices that perpetuate the harmful effects of discrimination and segregation. So, with that, we are an outgrowth, you may say, of an old public housing discrimination case, Walker versus HUD, similar to the Chicago case called Gautreaux and similar to the Baltimore case called Thompson. So that's a little history there, and it really lets you know that our focus is fair housing, particularly as it relates to race, the intersection of race and poverty. Next slide, please. There we go. So the crux and the heartbeat of what we do is our mobility assistance program. Our mobility assistance program is what's called the Housing Mobility Counseling Program. There are a few around the country, certainly in Baltimore and Chicago, which are the cities that had the cases similar to the Walker one that I mentioned, but other cities as well. And housing mobility counseling is a particular type of counseling that focuses on housing choice voucher families, those who are really have tired of having to be steered to high poverty, in our case, segregated neighborhoods. Sometimes people call some of these neighborhoods voucher submarkets, because that is where the landlords who do take vouchers have properties. And so that is often where they are forced to live because of the lack of options in other places. So our counselors help families with vouchers who are interested in making these type of moves locate this type of housing. We also do education on the front end, because actually the Dallas Housing Authority's vouchers may be used not only in the city of Dallas, not only in the county of Dallas, but also in the 6 adjacent counties as well. So that's a relatively large region. And sometimes families don't realize they have that breadth of geography where they can move. And they don't know that they have certain fair housing rights when it comes to moving to some of these, both suburbs and exurbs. The Housing Authority here administers around 16,000 vouchers. Our counselors educate about 3,000 a year. So they do housing, fair housing counseling, housing search assistance. We do move-related financial assistance, such as helping them with security deposits and application fees. Because of the locations where they're moving, those tend to be a little higher. And it was alluded to earlier, I believe, in Phil's comments, that sometimes a source of income discrimination bans or anti-voucher discrimination bans are a piece of the puzzle. And so we try to add other pieces to the puzzle to help people actually access units. So we do recruit landlords, and it is in our counselors' landlord recruitment process that they hear all of the redundant no's from landlords who won't take the voucher. Previous to the Urban Institute's research, we did our own research that we published on our website a couple of summers ago in 2017 that really showed our results from surveys of landlords. And we found that the proliferation of landlords who say no to voucher holders was great all over, but it was even greater in communities and census tracts where they were predominantly white, where the population was predominantly white. And so to that extent, this issue is extremely important to us. Our counselors also serve as a liaison to the Housing Authority. So between the Housing Authority and the voucher holder, they serve as a liaison, and as a liaison to landlords, because landlords have their questions and concerns. And sometimes our counselors can help answer those questions when they are trying to quickly move along in the process. And our counselors are also available to help with any post-move issues that might come up, things that might come up with kids' schools or with the landlord himself or herself, or things that happen after they've moved, or helping them identify resources in their new communities. Next slide, please. So in our effort to try to find units for our families and the rejections that our counselors have gotten, we try to listen to landlords who say no to voucher holders, right? I think some of the things that we hear a lot are they don't want to deal with the red tape, they don't want to deal with the federal government, et cetera, et cetera. And so trying to address some of these business concerns that we heard from landlords, we created kind of a demonstration program a couple of years ago called our Sublease Initiative. And the idea was to try to get rid of some of these things that landlords have been complaining about. So through our initiative, our demonstration initiative, our organization leases from landlords units, and we sublease those units out to voucher holders. We certainly don't want to do this on a large scale basis forever, but we wanted to get an idea of some of these issues that we heard that were going on. And so we literally sent hundreds and hundreds of letters to landlords who had previously said no to vouchers, inviting them to this program. And so within the last 2 years, we are about at 26 units with a handful of owners who say, yeah, I'll try it out. And so our organization is the organization and entity that pretty much deals with the housing authority. We get into the contractual relationship with the housing authority. We're in a contractual relationship with the housing trust voucher holder, and the owner of the complex actually has absolutely no contact with the housing authority for any reason. And so our families are thrilled that they've been able to get into some of these complexes that had previously told them no. But unfortunately, this reaction from the landlords has not grown as quickly as we had hoped, considering that we've tried to kind of diminish some of the issues that they brought out as to why they don't want to participate. Next slide, please. And so let's give you a little idea of anti-voucher discrimination issues here in Texas. I'll go through a little brief timeline. The city of Austin, which is known to be one of the more progressive cities in the state of Texas, passed a source of income ordinance. However, they came up against some backlash, and that was by the apartment association community, who actually ended up suing the city of Austin for having passed this. And so in addition to that, around 2015, it became known that the city of Dallas was contemplating passing a source of income discrimination ordinance. And that was because actually the city of Dallas had gotten in trouble with HUD, and there was a voluntary conciliation agreement regarding some HUD fair housing violation findings that they had. And so HUD suggested to Dallas, you might want to consider a source of income discrimination ordinance. And so they were considering it. In the meantime, though, before Dallas was able to get to that point, the Apartment Association's political action group lobbied the state. And so they went to the state back in 2015 to do a statewide ban on anti-voucher discrimination ordinances. So it really was a preemptive measure that kind of tried to like stem the tide of source of income here in the state of Texas. And so it was a hard blow. Obviously, it was pointed at the cities that were doing this or contemplating doing this. And to this day, that ban still exists. Next slide, please. And really, the Apartment Association group really heralded their successes. You can see this video on your own. They were very pleased about the work they did in lobbying for this ban. And I just say that to give you an idea of how difficult our uphill battle is here in Texas. Now, I will say that in addition to this preemptive measure, during 2015, our legislative sessions are every 2 years. During 2015, there were also many other preemptive measures that were passed. And even now, the state goes back into session this coming January next month, and already there has been a preemptive measure introduced on a different topic, but something introduced saying that cities and localities can't use local taxes to get rid of Confederate monuments. So we're dealing with something even bigger. As horrible as this situation is, even bigger than our source of income statewide ban. Next slide, please. I mentioned the voluntary compliance agreement already. So fast forward a few months, in 2016, the city council actually sat down and they considered a source of income ordinance the way HUD had suggested they do. When faced with two different versions, they chose to vote for the one that included the conditional language that said to the extent allowed by state law. And so as we know, the statewide ban said you can't pass one that would require landlords to take the federal housing program voucher. And so voucher holders are not protected under the current ordinance. Now, there was an exception made on the floor, the House floor in the state legislature, that said that an exemption would be for veterans. And so the city of Dallas has their ordinance. There is an exemption for veterans, but to date, the city has not advertised that very much. We've advertised it ourselves a bit, but they have not advertised that very much. Next slide, please. And so if you want to hear a little bit more about the state of affairs here in Texas, this link will take you to an article that talks about this issue. That was, like I said, that statewide ban was passed in 2015, but this article was just written very recently. So that lets you know that this is on the minds of people. It's just not on the minds of the people who had the attention of the state legislature back in 2015 and 2017. Thank you.
Demetria, thank you so much, and thank you for sharing what has been happening in Texas. We're really grateful to have you as part of this call, for sure. And I want to add that we do often hear in jurisdictions around the country folks saying, who are on the fence on source of income laws, saying something like, well, I'll do it, but I'll do it just for veterans, thinking that they'll just capture VASH voucher holders and take care of it. And I want to emphasize that, our folks, our men and women who serve in the United States military, don't exclusively use VASH vouchers. Sometimes they have access to regular Section 8 vouchers or housing choice vouchers. Sometimes they have access to other types of vouchers. It's a bit of a misnomer to think that veterans only use VASH vouchers. But it's also harmful to other folks who need housing assistance, who do not have income sufficient to afford housing without a subsidy, for them to be excluded. And I think that's very much your point, Demetria. So I just wanted to emphasize that as well.
And Antonia, this is Mindy, and I'll just emphasize that I did not use a VASH voucher. Mine was a regular Section 8 voucher, and I'm a veteran.
Yeah, and the exemption here in Texas just said veterans. It didn't say anything about VASH vouchers.
Absolutely. All right, thank you so much. Okay, we are going to progress the slides, and we are just in a moment to a number of the questions on the screen. The slide you have up is my contact information, as well as the contact information of my colleague, Paula Shapiro, at the ABA section on civil rights and social justice. Paula, you're not hearing her voice, but you should know that she has very much been the person to make this happen today, and I really want to thank her for her work in organizing and making this webinar possible. She is a fount of knowledge, so please feel free to email her with any questions. We will turn, right before we turn to the questions asked by our audience, I want to share one piece. Often when I do these webinars, I have law students, many law students and young lawyers ask me how they can begin to work on these kinds of issues, either as a law clerk or staff attorney at the different kinds of organizations that pursue anti-discrimination work. And so I wanted to share one opportunity coming up for folks who are in the Mid-Atlantic region. The Mid-Atlantic regional chapter of the National Black Law Students Association is actually hosting a job fair coming up in the new year on Friday, February 8th from 8 to 5 at the Westin Hotel in Annapolis, Maryland. And if there are any law students or young lawyers on this call who are interested in working with any organizations in the Mid-Atlantic area that work on issues like these, you have until December 28th to register and participate in that job fair. My own organization, the Homeless Persons Representation Project, will be there. If you are an employer and you would be interested in meeting law students and lawyers interested in working on these issues, I believe it's the same registration date of December 28th. So I just wanted to share that in case we get a question of that kind coming up. Okay, now we're going to turn to some of the questions presented by our audience members. We have one question as follows: how do you address the issue of requiring landlords to enter the Housing Choice Voucher program? Landlords report barriers such as inspection barriers and other reasons, bureaucratic reasons why they cannot enroll in the voucher program. How can source of income laws be strengthened to capture or address that practical barrier. I'm going to ask our Washington State folks to start with that, since I believe you've addressed that and addressed it successfully, and then the rest of us can add in. Scott, you want to jump in on that?
Sure, I can, or maybe you can too. So there's probably two things I'd say about that. One is that our law specifically permits a landlord to not rent to a person whose assistance requires an inspection prior to renting if the cost of that inspection hits a certain threshold. I'm not crazy about that, but that was the legislative compromise. The one sort of silver lining there is that we also created this mitigation fund, which landlords can draw on that to make those repairs in order to bring the housing up to housing quality standards. You know, it's an open question how serious a problem this could be. We haven't seen that issue come up yet. In my experience, most HQS violations are not super expensive to repair, but I suppose you could have a place that was really in need of something serious. It's going to come over this threshold. But again, the landlord can access our fund to pay for that, and then has to rent if they use that money. So it undermines some of the reasoning there. But yeah, it's a compromise, and it creates a bit of a dilemma for us.
I will add in the city of Baltimore, which is contemplating a source of income bill at the moment. The city recently passed in multifamily rental housing inspection requirements, and the voucher inspection will be sufficient for the city inspection requirements. So the idea is that if a landlord is participating in the voucher program, they will not have any additional inspection burden based on that. So that's one way to consider it outside of the legislative process.
And can I?
Oh, yes, please go ahead, Demetria.
And I'll just say that obviously we don't have an ordinance here, but through our housing mobility program, when we're talking to landlords, asking them to participate for the first time, one of their concerns is, well, I don't have time to wait for a first month's rent, waiting for an inspection. And so we are able to offer a landlord incentive to get them to participate and kind of tie deal with that period of time before the lease actually goes into effect. I'm just saying that for people who are contemplating writing ordinances to consider something like that might help. Maybe the mitigation fund, I don't know if it deals with that piece of it, but that's an idea.
And this is Mindy, and I will say that I think that if the inspection is a delayed inspection, that that landlords can also pull up to 1 month's rent from that landlord mitigation fund as well.
Good to know.
And Mindy, just staying with you, there was a question for you in particular about the total length of the voucher extension that you received.
I only received one extension. They have the ability to do multiple extensions, but my case manager said that because there were so many other people with a voucher in hand and nowhere to use them, that there was no point in giving me an extension, so they would not give me one after. So I just got one. So the total length of my mobile voucher was 8 months. And so I got my apartment 2 days prior to the end of that extension.
Thank you. Moving on to a new question. Someone asked, under source of income, we heard that there was a 3-month delay in getting the first rental payment for a voucher holder. I assume that means from the Public Housing Authority or the voucher program. Was that a local fluke or a broader problem? I will add, I will open that up to folks, but I'll add in the state of Maryland, in Baltimore City, the Housing Authority pays landlords at 2 different intervals every month. So the amount of time that the landlord would wait for a rental payment for the first month wouldn't be more than 15 days. So my sense is that's a local fluke, but I'll invite others to add in.
I've not heard of a delay that long.
That's ridiculous, yes. But
yes.
Alison, are you still on?
I'm still here. You know, I think that it definitely depends on the local housing authority how long they take to process everything. So, you know, a delay of that long would be very unusual. But I think what's important is even though there may be a delay to receive the first payment for processing requirements, you are always paid back to the day that the lease started. So you would be reimbursed for any time that lagged between your lease update and when you actually received a HAB payment in your checking account. And then beyond that, payments would be, you know, almost everyone's doing direct deposit now. Payments would be in there on the first of the month. So I'd say that'd be an unusual circumstance, but remedied by getting paid back.
Yeah, we like I said, we're landlords to a certain extent as well. Through our sublease program, we have not had to wait 3 months. There is excuse me, a regulation in the HUD regs that say that initial payment may take longer than 30 days. But again, you'll always get all your money. And I think the front ends mitigation fund, that kind of thing, could be available and kind of built in if a landlord needs the fast cash. So we haven't had to wait 3 months to be paid.
I mean, I should just add to this discussion that I mean, it's great that there's a mitigation fund and there's that kind of landlord incentive. But if you have a source of income discrimination law that prohibits discrimination against voucher families, you know, the courts generally have viewed all the aspects of having a voucher as being part of what constitutes discrimination, whether it's the Section 8 lease or the inspection or the fact that you have low income or you're participating in a government program. I think those are all, whatever those excuses are, those are all aspects of discrimination. I think the analogy that I find to be the most useful is the Fair Housing Act provision prohibiting discrimination against families with children. Now, if I'm a landlord, I may have some very good reasons, quote unquote. I don't want a baby in there or teenagers or, you know, kids who in my mind are going to be causing damage to the premises or whatever, who are going to cost more, who are going to make other tenants upset. But it's the law. It doesn't really matter what the problems children cause. You're not allowed to discriminate against them in the program. Same is true of a voucher family. Whatever the things associated with being a voucher tenant, that comes with the territory, and you still can't discriminate against that family. So I find that analogy to be very helpful, and the courts have also.
I'd add to that just a little bit, Bill, which is we had this mitigation fund last year, and it was a smaller amount. And, you know, this is based on this idea that Section 8 tenants cause all this damage. And there were 6 claims, only one of which was allowed, you know, in a 6-figure settlement. Right. So, you know, I think landlords are a little more hip to it now, and they're probably throwing things at it that may stick more now. But I just, it's sort of a red herring in the sense that, you know, we did this, but it's just not a reality that we see. We see the opposite. Landlords charging for stuff they can't charge for.
Moving on to a new question. We have a question asking about Philadelphia's law. So, Phil, I'm going to turn this to you. The question is, could you explain what hybrid means with regards to the source of income law there? Do you happen to know the answer? Mm-hmm.
I do happen to know the answer. I think they were testing in the region, and Philadelphia City has a anti-discrimination ordinance that covers voucher families. I don't know if it has an effective enforcement regime, but the counties right outside of Philly, you know, Delaware, Montgomery, Bucks, and the other one, Chester, you know, they, as far as I know, they don't have a source of income discrimination law. So to the extent you're testing outside the city, you run into that issue. So I think that's what the term hybrid meant on the chart.
Thank you, Phil. This next question is for Demetria. This is from someone who is a mobility counselor with the San Diego Housing Commission. San Diego has a source of income law going into effect August of next year. And wants to know what the most successful incentives are in your program that you're using to recruit new landlords into the program.
So without an ordinance, pretty much when we're able to recruit new landlords, it's not the large apartment complexes, it's smaller complexes or it's single family houses. Those are the landlords who have a little more flexibility in making those decisions. When you're dealing with large apartment complexes, then it becomes a corporate issue. And it is those corporations that we sent the letters inviting them to participate in our sublease program. But when our counselors are looking at, let's say, condos or townhouses that are out for rent or single family houses that are out for rent, usually talking to them one-on-one and really kind of holding their hands helps, explaining the program and really kind of talking through whatever they need to talk through. We've even had counselors physically go down to the housing authority to meet a landlord, just kind of to ease their maybe anxieties or whatever about, you know, the process. But the landlord incentive bonus has helped recruit landlords into the program to the extent that maybe they'll consider lowering the rent so that the voucher will cover the rent, or maybe, like I said, on that front end, waiting for the couple of weeks, maybe more, that it might take for the program to kick in.
Thank you so much, Demetria. The next question is for Scott. Someone has asked you to reiterate the human rights item you spoke about in your presentation on your slide.
I think what you're mentioning, I've got the slide in front of you, but I think we have a human rights law that addresses discrimination against protected classes in all the usual areas, and that would be a natural place to just add source of income into what we have a state enforcement mechanism, administrative enforcement scheme. Our state attorney general's office enforces that law, as well as fair housing laws. And so my point was that source of income discrimination did not land in that human rights law. It landed in our state rental housing code. And so it doesn't take advantage of the administrative enforcement mechanism that our state human rights commission engages in, which would have been a fairly straightforward complaint process for a tenant to just file a complaint with the state rather than file a lawsuit. So I think that was my point. I hope that answers your question.
That's great, Scott. Thank you very much. And I'm just checking for new questions at the moment. I think those are all the questions that we have at the moment. If you do have a question, please feel free to post it and I will try to catch it. But while we're doing that, I will turn here to the next slide. If you are interested in being a part of the work of the American Bar Association to push this issue forward or other similar issues, I encourage you to join me and my colleagues in the section on civil rights and social justice. There is a link here to become a member of the American Bar Association. There is a special dues rate for public interest lawyers. There's also special dues rates for judges and other folks, so I encourage you to take a look at those special rates. And then the section membership for our section is only $45. And as I mentioned, I'm part of the Economic Justice Committee, and we are a very active committee, and we would love to have more folks join us and push issues like these forward. So we absolutely encourage you to do so. Again, please continue to follow this work going forward. There's material on source of income discrimination and other kinds of important issues that the committee puts forward on Twitter. You have our Twitter handle there, the section's Facebook page, and then the website for the Civil Rights and Social Justice section there. And we would be glad to have you follow our particular work. It does look like we have some additional questions. Just bear with me as I pull them up. Okay. We already talked about barriers. Yes, we have a question here about, Maine has a source of income law as part of the fair housing laws for the state. What we find is the idea that a landlord can refuse a voucher if they are compelled to use the tenancy addendum that is made part of the HAP contract, that's the Housing Assistance Payment Contract, and the lease as violation of contract, where he cannot be compelled to have a lease. I'm sorry, this question is just a little hard to read, but I think the question has to do with compelling, whether landlords can be compelled to join the program if they have to execute this additional addendum to the lease called the HAP contract. Would someone like to speak to that? Phil, why don't you take that up?
I would just ask the person who asked the question to email me, because I'm not really tracking this and I don't know the case, and I'd be very curious to learn more. I'm just ptegeler@prac.org. I'm probably on the, we can take that offline. I think that sounds very unusual and not the way that these laws are normally handled. That's a sort of central part of the voucher program, which would be included in the prohibition. So I'm a little surprised to hear that, and if the person could just email me at ptegeler@prac.org, I'd like to hear more. Thanks.
Wonderful. Thank you, Phil, very much. Okay, I am looking for additional questions.
Antonia, I wrote 2 into the chat if you need more, just so you know.
Thanks. Yep. No, I think we have some from audience members here. Here's one asking for ideas on how voucher recipients can better access housing in higher priced markets in which property managers employ systems that change rent prices weekly or daily. These places often won't lock rent in for more than a few days, and by the time the Public Housing Authority signs off on the lease, rents have changed, possibly exceeding the voucher amount. Would someone like to take that on?
Well, the first question might be what are the payment standards in that particular jurisdiction, right? And so if someone's in a relatively hot market, hopefully that jurisdiction, that housing authority does or has sought to use small area FMRs, which is, it's kind of wonky, but it's basically saying that market's going to be based and looked at on kind of a zip code level, so that we're not talking about one macro figure, let's say for a 2-bedroom. So that's the first question. And that certainly is a very critical piece to help people access lower poverty neighborhoods. So certainly it has been the case here. We've been using that since 2011 and it's made a tremendous difference. But to the extent that those rents vary, if your payment standard is actually close to the market, that variation shouldn't be so terribly huge, because, well, at least here in the Dallas market, we do have apartment complexes that use that computerized system where rents vary. So I think the first question is whether or not that jurisdiction is actually using a tool that's available called small area FMRs.
Thank you, Demetria, so much. We have an additional question coming up about Baltimore. And the question is, in Baltimore, we have recently lost one of our organizations which focused on fair housing and the mitigation of discrimination in housing. How do we gain information about local testing? So that's true. Baltimore did lose its principal testing organization. It is my understanding that there is a group mobilizing right now that involves a number of local advocates working to reestablish a new testing organization. But in the absence of that group, I would encourage folks who have witnessed or experienced housing discrimination to report those to the local or state commissions that review fair housing complaints. There's one in Baltimore City. There's also the State of Maryland Commission. In Baltimore City, we have a Commission on Civil Rights you can report it to. You can also contact, for folks experiencing voucher discrimination, you can contact the Homeless Persons Representation Project. My contact information is on the slide. The ACLU of Maryland, and other organizations, just until we get that reestablished. Okay. There has been a question asked about the appetite for source of income discrimination in Congress. Alison, do you think you could speak to that? Or I should say the appetite for prohibiting source of income discrimination in Congress.
Antonia, that's the question I asked you to speculate on. But I will speculate on it.
Okay.
So there's, I think, 3 different proposals, one in active, one in the House, and 2 in the Senate. And as Congress has been grappling with the latest showdown over the budget, it's unclear where people's attention is right now. But I think we're expecting that more types of these laws will be introduced in January when the Democrats take over the House of Representatives. But given the bipartisan nature of the bill that was introduced in the Senate, it seems possible that it could also get taken up over there, although Senator Hatch, who is the Republican who introduced the bill, and Senator Tim Kaine from Virginia is the co-sponsor, will be retiring as soon as Congress is out of session. So it's not clear what would happen to that bill at this time. So I think it remains to be seen, but what I would say is what we think here in DC is that all of these efforts at the state and local level build momentum, and the more areas that get covered by source of income protection helps build the case that it makes sense for this to just go ahead and be nationwide. With 1/3 of voucher holders already covered, we could look at that as not so great that only 1/3 are covered, but in the other sense, 1/3 are covered, and so it wouldn't be that much of a stretch to cover everyone. So the efforts that you do at the local and state level, I wouldn't want to discourage them in any way, thinking that something might be coming down from Congress. It's possible, but your efforts to expand this greatly help those federal initiatives just by showing demand for these types of laws. And it's from my perspective, I have a question about what is the best language for enforcement, what are the best methods, and with you guys out there testing different ideas and different incentives for landlords, I think it will help us make a better legislative pitch once we know what is most effective. So, it'd be great if federal source of income protections passed in January or February, but it's also great for you guys to explore at the state and local level what's really working and what makes the most sense in providing that feedback. So that's my long rambling answer. Is that good?
Thank you, Allison. That's great.
Gold star.
We have a question from someone at Legal Aid in San Diego who says that some advocates are still wary of landlords finding a way to get around source of income anti-discrimination ordinance, such as adding new screening procedures and effectively still being able to discriminate against voucher holders. She has a question specifically for Scott. What are some of the specific landlord methods that you may have faced and arguments or approaches that you've used to combat them in that context? Scott, I think you're on mute.
Sorry about that. So there's various theories the landlords have come up with as to why the law doesn't apply to them. Those are, fairly easy to get past. I think we're concerned about landlords manufacturing the idea that the place is not HQS compliant and that they therefore won't have to rent it. The law requires written estimates for those costs, and so assisting on those. In getting more to sort of what are other ways, I think landlords we've seen them start to increase the amount of rent required or amount of income required to rent. So instead of 3 times, it's 4 times. Only offering month-to-month rental agreements versus year leases, which I addressed earlier. Basically, landlords who are knowledgeable about how the program works, what the requirements are, and moving around their screening requirements to make it burdensome for the housing authority to comply tend to be what we see. So another one I was just thinking of, but it's escaped my mind. Basically, that would be, generally speaking, the ways in which compliance has been made difficult where we've seen it. So yeah, I don't have a whole lot to add to that. The strategies for dealing with that are, we have an advocate here who wrote a really compelling sort of 2 to 3 page letter about why source of income discrimination is illegal, why it's a fair housing violation in addition to being illegal under our state law, why the myths about source of income discrimination are not true, and that we're willing to take landlords to court when we find they're still unwilling to rent to our clients. And that has been pretty effective. If you want to email me, I can share that letter with you. I think it's a really great letter our lawyer drafted, and we've been giving it to advocates around the state to use to sort of read the riot act to the landlords and tell them, like, this is the law now, and this, you got to comply, and all the shenanigans about trying to get out of it are not going to be very persuasive to a court if we get involved. The other one I was going to mention is landlords being knowledgeable about the payment standards and trying to increase rent or to put things within the rental agreement that are unpalatable to the housing authority. So special clauses for Section 8 tenants, like you got to rent your own washer and dryer if you're a Section 8 tenant. A lot of that stuff is now illegal, but they still try it. But yeah, I think that letter is pretty effective at warning off most of them, unless they're real die hard about it. And then, that case may need to end up in court.
Scott, thank you.
And to the Antonia, to the extent that the requirements are brand new, following on the passage of a source of income discrimination law, or that they're not applied generally to all tenants, those are basic, hallmarks or evidence of discriminatory intent, and you just, that's just like litigation. You have to use those as facts that are consistent with your theory of the case, because they are evidence. You can't just say, oh, we're going to raise the rent now because this law went into effect. We're going to raise it $5 above the payment standard. That's just not going to fly.
Yeah, I agree.
Really, really good point, Phil. Thank you. And I am receiving a number of comments from folks who would like to see that letter. So I put up, that Scott referenced, I put up Scott's email on the screen. So folks, please email Scott directly. We are not going to include that letter in the general information available from this webinar, so please email him directly. We do have a comment from someone in Baltimore that says there is an interim board attempting to reestablish that fair housing testing organization that I mentioned before, and that the National Fair Housing Alliance is providing assistance during this interim period in helping that organization be set up. So I want to thank the person who provided that, and folks can certainly contact the National Fair Housing Alliance in the interim as well. So thanks very much for adding that. We appreciate it. We did, Allison suggested, and I think this is really appropriate, to talk about the range of unit sizes and rentals that source of income laws usually apply to. And this is a very, very good point. Oftentimes, almost universally, owner-occupied rentals are exempted from source of income laws across the board. Primarily, it's very difficult to navigate the process if you're renting a room in your apartment. Oftentimes, we have owner-occupied exemptions for other types of protected classes, such as gender, for obvious reasons. So those are exempted. In about half the jurisdictions in Maryland that have source of income protection, there is a very small landlord exemption. It's usually a one unit exemption. So if a landlord owns one additional unit or house, there's an exemption for that. But that's only in about half of the Maryland jurisdictions. The other half apply fair housing protections to every rental unit other than owner-occupied. Phil, you may have a national perspective on those kinds of exemptions as well.
Well, we prefer not to see exemptions, but certainly the kind of exemption pioneered by the 1968 Fair Housing Act, based on owner-occupied small, like duplexes and things like that. Even though they are often the best source of rentals in high opportunity areas, for example, in the Baltimore region, find a lot of those small rentals being very valuable. I think it's pretty common to see those exemptions. I mean, we object to them, but we understand, where that comes from.
Absolutely. So without further ado, I don't see any additional questions. If you do have any, you have about 2 minutes to send them in. But I've scrolled back now again to the membership section of our presentation. Again, if you are interested in joining the American Bar Association's efforts in this regard, please join us as an ABA member, and in particular, a member of the section on civil rights and social justice. It's a really fun group. We do stuff like this webinar, and we push for the ABA to adopt policies like the policy on source of income so that advocates can use it in their efforts to champion source of income laws around the country. So we'd very much like to have you join us. And I will add, you don't need to be a lawyer to join the American Bar Association. So if we have more non-lawyer advocates on this call, we would love to have you as part of this pool. Not seeing any other questions here, I will start to wrap up the call. I want to thank all of the panelists who participated in this program. Jill, Alison, Phil, Mindy, Scott, Demetria, it was fantastic to have you, and I thank you so much for sharing your experiences and expertise with us. We're so grateful to have this, And to the audience members, the materials from today's program, again, will be emailed out to you. They will be posted on the ABA's section on Civil Rights and Social Justice website if you would like to reference them. Any final words from the panelists?
This is Mindy. Just thank you for having me.
Thank you so much.
Thank you.
Absolutely. A pleasure to be with all of you. Thank you all for joining us. Bye-bye.
Bye-bye.
Thank you.